Hi, welcome back to Law Unfiltered. Now today I have another special guest with me and I'm very honored that he has agreed to come. His name is Haijan Omar.
Hello, hi Celine. Hi.
Thank
My
you
name
for
is
being
Haijan.
here.
Yes. Thanks for having me, Celine, in your podcast.
No worries. It's my honor. Do you want to introduce yourself?
All right. Hi, everyone. My name is Haijan. I'm a criminal lawyer. I've been in practice for about 17 years. I do a diverse range of criminal cases, including but not limited to murder, kidnapping, drug offences, including trafficking.
In Malaysia, we used to have mandatory death penalty. Now, death penalty is only subject to several offences, for example, murder, drug trafficking, treason. These are all the offences that also there is a few more, but for the purpose of today's podcast, it will be mainly on drug trafficking and murder. So these are the offences that is subject to mandatory death penalty. Now, up until 2023, the Parliament has approved the Abolishment of Mandatory Death Penalty Act. Now, death penalty is no longer a mandatory thing, but discretionary at the court's discretion. So for today's podcast, we're going to start with drug trafficking. Now, how do we prove drug trafficking?
Of course, the most important element in drug trafficking to begin with is that the prosecution must prove the element of possession. Possession in bahasa it means milikan or memiliki. That means you are in possession of the impure drugs. But possession is of course is a legal term. There's no real definition of legal definition under the Act what it means by possession. But of course, the Dangerous Drug Act provides that in order for you to prove possession, you have first to prove custody and control as well as knowledge. So these are the two things that they have to prove in order to prove possession. Secondly, they have to prove that you not just possession, you have to be in traffic of the drugs. So in order for them to prove trafficking, of course they can prove either by way of direct evidence. That means they have to show that he either manufactures the drugs, he distributes the drugs, he sells the drugs and all that. But must be by way of direct evidence. That means there must be a witness who will say.
Can I give an example? If you caught me driving a truck full of drugs, does it constitute to trafficking?
It's something that the police must investigate and gather the evidence and prove their case in court.
But yeah, I'm already driving the truck full of drugs behind there. So does that look good for my case?
Of course, on the face of it doesn't look good. For sure, you'll be remanded for the next 14 days. That doesn't look good at all. But it's for the police to prove. They have to prove that he has knowledge
that the
of
truck is
the
filled.
contents of what's inside the truck. Truck, right? So if they cannot show that he knew or he knows of the contents, then they have not made out a trafficking case against him.
So what kind of defense are you gonna come up with if I'm caught with a load full of drugs in the truck and I'm driving it?
Well, of course, the prosecution first must prove they will try and mount a willful blindness on the part of the driver, right? The driver has a duty to inspect what he's carrying. So, but of course, if he's just assigned to the truck, right, to convey the contents of the truck from one place to another, all right, then of course everything was packed, sealed. There's no way that he could have checked, right? So it's something that you have to poke holes in the case for the prosecution. Yes, So that's basically it. But it really depends on the facts and circumstances of the case at the end of the day. I can't say for sure, what is the difference for a truck driver A and a truck driver B, right?
I'm just saying like example what if one day I'm driving a truck with a lot of drugs.
I think in order for you to expect that to happen, right? You have to be careful before you actually do it.
Yeah.
So you have to take efforts.
Now you talk about that, right? Another thing that is quite common, I don't know if everyone is well aware of this already or not, but they always say that when you're at the airport, you're not supposed to help other people to look after their bags. I think now I'm not sure if everyone has already known this or not, because okay, what if, I'll give you another example. I help people look after their bag, and then after that somebody come up to me and they want to spot check my bag because apparently inside is filled with drugs, and that bag is not even mine to begin with. Now how?
But it's not your bag, right?
how
You mean that you are asked to check in the bag?
I'm
Under
asked
your
to
name.
I'm asked to, for example okay, I'm at somewhere, and then some girl say I'll need to go to the toilet, can you help me look after my bag for
Alright.
like 5 minutes?
Alright.
And then the lady obviously never come back, and I'm holding the bag. Suddenly this bag becomes mine already.
Right.
The prosecution,
Before the check-in, of course.
yeah. The prosecutor can say whatever they want. So what's going to happen to me? Does it look good for me?
They will have a reasonable suspicion the moment they are found that you are
Holding the
within
bag.
the proximity of the bag and holding the bag, right? They will investigate. Of course, you will be remanded. Alright, for sure you will be remanded.
For another 14
They
days.
need to investigate. But I think if it's not yours, then you can prove that the contents of the bags, including the other contents,
Which only has
not
drugs
just-
in there.
only drugs.
CCTV perhaps.
Then perhaps
Yeah.
you have to look for the CCTV.
Yeah.
I guess. Yeah.
Another thing is for drug trafficking. Now I'm aware that every drug has a different threshold, right? Different weight threshold for there to be drug trafficking.
Right.
So that's also one thing to take into consideration. Now once a person is actually proven to have drug trafficked, what will the court take into consideration in deciding the punishment of death penalty? Now, because there is no more mandatory death penalty, now it's being substituted. For example, if the court does not want to grant death penalty, then the person will be imposed with a imprisonment, life imprisonment, which is like 30 to 40 years.
Life imprisonment is 30 years.
And then after that, and also whipping, maximum of 12 strokes. So that is the alternative of it. But now the thing is like, because it's quite new now, and I've seen that a lot of there are now a lot of applicants applying to court to reverse their punishment. The thing is that what I'm not very sure is how does the court decide on whether to reverse the death penalty or not?
The only instance that I have come across that High Court actually imposed death penalty regardless of the new
2020
amendment,
okay.
right? Is a case in Tawau in Sabah, if I remember correctly. But that involved lots of
Drugs.
drug seize, and also it's a manufacturing case. Right, but I'm not sure what's happening after that, because you can
appeal.
The accused persons have avenues of appeal in the Court of Appeal and Fair Court. But thus far, of course, what I've seen, my limited
Experience.
time in Court of Appeal and Fair Court, and in the review of death sentence cases, I have not seen that the court actually maintain death penalty for drug trafficking.
I see.
So far. Correct me if I'm wrong. But of course, court has maintained death penalty for they always they reverse and they substitute it with life imprisonment and 12 strokes over time, like you said.
Okay, right. Now, other than drug trafficking, like I said, murder is also one of the offences where court will impose death penalty. now it's at the discretion again, like I said. Now, how do we prove murder?
Murder is the most serious of offense of
Yeah.
you know
The person can commit.
killing someone, right?
Yeah.
But of course, there's a lesser offense of
Murder.
murder.
Manslaughter.
Yeah, but manslaughter is an English word.
Basically, with no intention to
Right.
kill. Maybe I accidentally pushed Haijan and then he, unfortunately, touched wood. Okay, not Haijan. Okay, another person, and suddenly the person passed away. So I don't have the intention to kill the person. I just pushed and he died. So that's like manslaughter. In layman terms.
Yeah, so but I just want to correct you in the sense that
Yeah.
we don't use manslaughter here. Of course, most lawyers they use manslaughter easy.
Yeah.
It's a short form.
Yeah.
Right? But here, what manslaughter here means is a culpable homicide not amounting to murder,
Which is manslaughter.
which is manslaughter. That's right. But the term that we use
Yeah,
here
yeah,
in
yeah.
Malaysia is
In penal
culpable
code, yeah.
homicide not amounting
Yes.
to murder. So, first, of course, in order for court to decide whether it's murder or not, of course, it's for the prosecution
To prove
to
the case
charge
as well.
and to prove.
Yeah.
Okay, they were charged with the
Most serious
ones, and it's for the court to decide whether it falls under the sections. If it falls under the section, say for example, if it's sudden fight, if it's a grave and sudden provocation, exceptions 1, 2, 3 of the section 300 of penal code, right? Then it falls under the case of culpable homicide or murder. It's for the court also to decide as to the degree of the injuries of the acted serious, whether or not it amounts to one. Of course, under culpable homicide not amounting to murder, there are two categories. One, both are under section 304 of the penal code. There are two links to section 304. One is section 304A. This is the most serious offense of culpable homicide not amounting to murder. It entails a punishment up to 30 years, as well as whipping. Whereas the lesser offense of culpable homicide not amounting to murder is under limb B, which entails a punishment up to 10 years of imprisonment only. So it's for the court to decide as to the degree of
The
the
offense that was
offense under culpable
or
homicide.
the act of it.
The act of it.
Yeah.
So it really depends. It all depends on the injuries sustained by the disease, the act committed itself, whether or not it's driven by motive and whatnot.
Yeah.
So it's for the court to decide already, and it's for the lawyers to argue otherwise.
I think the motive is the one that is most concerning, right? Because motive is the one to decide whether it is going to be murder or I can't remember the full name, manslaughter. I'm just gonna say that.
Culpable homicide.
The culpable homicide,
I know
yeah.
it's a bit too long.
Too long, yeah. Because we
it's-
always say manslaughter because we don't want to say the whole thing. Yeah.
There's a short form.
Yeah, short form. Yeah.
Alright.
But basically, motive is the one that will distinguish which one is it.
Yes, because motive you can deduce from your act, right? You can deduce motive, and from motive you can say whether or not he has any premeditation plan,
Yes.
right?
Yeah.
That, certain plans have been put in place in order to commit the act.
Yeah. I think this
So
is
of course all that will be taken into consideration by the court
Yeah.
in finding whether or not he's guilty under
Culpable.
offense of murder or
Or
culpable
culpable
homicide, and also the sentence to be imposed.
Yeah. So let's just say, for instance, if a person is now proven to have murdered somebody, okay, and now the court again will have to decide whether to to impose the punishment of death penalty or not. So the thing is, like, it's such a fine line, whether you want to impose death penalty or life imprisonment with the 12 strokes of whipping. The thing is, like, I can understand drug trafficking, why some courts do not want to impose the punishment of death, but how do we now decide, how do we know what the courts will take into consideration in terms of whether to punish the person to death penalty when a murder offense has committed.
I think it's very. I mean, so far I think they have not. We have not have a definite doctrine
Yeah.
to what the court
Well,
must
how the
decide in
court will
order
decide, yeah.
whether or not is a murder that entails death penalty or life imprisonment. But of course, we have a doctrine in India, for example, right? I mean, this doctrine stem way back from the 70s, and the doctrine called the rarest of the rare case, right? So the court, and that also that doctrine holds that that the court can only impose death penalty in the rarest of the rare case. That means the most heinous, the most terrible case of murder.
I mean, one of the example that this doctrine was used in was in the UNPS bully case.
Which case is that?
UNPS, the one that several students they attacked the deceased because one of those attackers thought that the deceased has stolen the guy's laptop.
I see. The bully case in
The bully case.
in Army University. Yes,
Yes,
that's right.
I remember correctly. Maybe I'm wrong, but the Court of Appeal actually said that this is one of the rarest among cases because of the severity of the injuries sustained by the deceased at the time. It was not. It was subject to inhumane torture. That's what the Court of Appeal judge said. And so this, a few of the accused, I can't remember how many, was subject to death punishment. And that was already after the 2023 abolishment of the mandatory death penalty. So I think what you say is, it makes a lot of sense. Like when it is already so rare or like rarest among all of it, then the court will actually decide. But again, how do we decide? How do we know if it is the rarest among?
It really depends on the facts and circumstances.
Yeah.
Of course, the facts and circumstances of each and every case,
It's different, yeah.
vary, right? I mean, you know, it's all human condition. But of course, you know, it's for the court to decide. And just to, I mean, you know, when you mentioned UPNM case, you know, at the point in time in Court of Appeal, of course, that's what was decided.
Yeah.
But I think it was reversed by the
In the
court,
federal
the
court.
federal court. But on a different point, because you know the court thinks the court held that that it's not an offence of murder, but it's a culpable homicide. That's why the court reduced it and imposed a sentence of 18 years, as I recall correctly. That's what happened. But we have seen, you know, even after review in the federal court, the court has maintained death penalty in an exceptional case. For
Okay.
example, we have seen, you know, that murder of Susalawati, right? The businesswoman, right? And we followed the case. We understood that's what happened. You know, that she was kidnapped, then
Killed.
she was killed, she was thrown out. So
Clearly, there was like the
clearly
motive there.
there was a
already.
motive.
You planned the whole thing.
and they had a mastermind. All this was planned
Yeah.
with a group of people.
Yeah.
So and also the motive. Why did he do it? So all that, of course, court took into consideration, and the court maintained death penalty for the
accused
persons there.
Yeah. So perhaps we need more time to find out how the courts will exercise that particular discretion to impose death penalty, then taking into account that it's still quite new. I would say it's 2023 that this thing has happened. Now, last part of this podcast is just a fun question. Okay. Now, recently, someone, because of this abolishment of death penalty, right? So now it is imposed with, the other punishment is life sentence, imprisonment, or 12 strokes of whipping. So somebody went to federal court to argue that whipping is unconstitutional because one inmate, after receiving the punishment of whipping, after he was hit lah, basically, the inmate passed away from the injuries sustained. So somebody come and say that, oh look, this is unconstitutional. Okay, let's think about it. Do you think that it is unconstitutional to subject a person to whipping, for example?
I think my answer would be this. As of now, the status quo is that it's constitutional.
Yeah.
Okay, that's what the recent federal court
Has decided.
decision has decided, right? But if you personally speaking, I think whipping is a inhuman and cruel form of treatment. So I think we as a modern society, we should do away with whipping.
Okay.
That's my personal view.
But what about, like, okay, so I've asked a few people about this as well. I mean, like, just like a fun conversation, and then they were saying like, no, it's not, which I kind of think that it is not unconstitutional too, because, well, obviously you have committed a severe crime for you to receive the punishment of whipping. Even with the punishment of whipping itself, people is still doing the same thing. This doesn't seem like, because the whole purpose of having punishment is to deter other people from committing that offense again, right? So to tell the society to behave accordingly. Yet, with the punishment of whipping here, people are still doing the same thing. So some people then say, if there is no whipping, then where is the deterrence towards the offense?
I think imprisonment also a form of deterrence.
But in another way,
long sentence of imprisonment also
that's
deterrence.
okay.
Even coupled with whipping, people still did not deter people from committing the same offences in the future. So it's for the policymakers to come up, that's my view, right, with a suitably and apt punishments in substitute of whipping. So it's for them
To decide.
right? But of course, as a progressive and modern society, I think we should do away with whipping, because I think it's
still inhumane.
It's not consistent with the international standards of human rights.
This is one of the arguments that came out in the federal court case that happened recently. They said that the dissenting judgment was that international treaties or other countries, they don't have whipping anymore, actually. So as a progressive country, like you said, in a modern society, we should perhaps review back on the whipping sentencing, whether it is really in line with what we want to achieve as a modern society. But do you think that our federal constitution should be interpreted according to what international treaties say?
I think it's not according to
International.
the international treaty, because our federal constitution is supreme law of the land. It stands on its own. Right? I don't think it should be influenced by other extraneous factors, especially foreign factors.
Yeah.
Right. But I think we have enough fundamental rights, provisions in the federal constitution where the court can interpret it broadly, right? As to quote, the late Gopal Sriram, right? To interpret the provisions of rights housed in the federal constitution prismatically. That means you have to have angle it towards that rights. So here, I think the argument was that, that the whipping will likely cause death, right? And if that execution of whipping is carried out on him and he's caused death, then of course it's double. So he's imposed for
Whipping, but then he succumbed to the injuries.
Imprisonment sentence, but at the same time is
he's taking the risk.
It's akin to sending him to gallows. It's death.
Yeah.
Right?
Well, if you put it that way, it
So
seems
of course,
like, yeah.
it's for the court to decide prismatically to look at the rights, whether or not that impinges on Article 5 and Article 8. And I think there's some weight to the argument that it impinges on Article 5, because you can only be no person shall be deprived of his life and liberties in accordance with the law, right? If he's only sentenced for imprisonment, he cannot be sentenced to death at the same time.
I think this is something that really has to be said over and over again, because sometimes when you look at comments on Instagram, social media, especially in this kind of like heinous crime cases, the comments are always like, why is he still able to have lawyers? Why is he still this and that? I think it's not emphasized enough that we have rights under the federal constitution. Everyone is subject to liberty of life, and you have rights to have lawyers, because unless proven, this person is still innocent.
Yes.
Even though it doesn't seem like it at the first glance, but you don't know. So I feel like this has to be emphasized again.
Correct. I think it's a perception of society, right?
Yeah,
That,
perception.
only those who have the means is entitled to be defended by lawyers. I don't think that's right.
Yeah.
Because we have protection afforded to those facing
Death.
capital punishments,
Yes,
right?
yeah.
They're entitled to be defended by lawyers.
Because-
You have public defenders.
Yeah.
You have counsel assigned by court.
Yeah.
You have public defenders like YBGK, right?
Yeah.
You have all that.
Yeah.
So
But the thing is that-
there's always access
Yeah.
to legal
And there must be
defense.
access to legal defense, right? I'm not sure if you remember, but the last time, right, I saw a lot of people commenting on the stabbing case in the school, that one. And then Kitson Fong is the defense lawyer now. After it has been announced and then it's on the news, and then people commented like, how can he still have lawyers to defend him? How can you defend this murderer? Things like that was like being said on the comment section. See, again, like, again, has to be emphasized. Everyone under the law is equal. Everyone has to have the access to a defense counsel or lawyer, anyone, legal advice. So
We don't know the full story.
we don't know the full story. I know even at
We
first
don't
glance
jump
it
into
looks
conclusion.
bad, but
We don't jump
yeah.
into conclusion until we have the full facts.
Yes, correct.
I don't think there's a more prudent thing to do for all of us.
To jump to the conclusion that-
right-thinking members of society.
Yeah. Okay. Anyways, we have come to an end to this episode. I had fun. It was. Why are you doing this? Was it very stressed for you? So I hope this episode has helped you to understand the law just a little bit more than before. I hope so, and I hope it's useful to you. And thank you once again for coming.
Thank you, Celine. I hope whatever
We say,
I say today, makes sense and enlightens.
yeah.
Thank you.
Thank you. See you all in the next episode.